Well, howdy, everyone. We've done this a couple of times when there is breaking news. So rather than doing our stupid jokes during the sound check, we're going to talk about some substance. So it was a big week last week. Actually, three things happened. President Trump talked about surprise emergency room bills. New guidance came out about the co-location of space in the provider-based settings, and that will be the topic of our whole next webinar in June. And then some guidance came out from the Department of Justice about the False Claims Act. So I'm going to start by just explaining quickly what happened, and then Kevin and I are going to talk a little bit about our take on it. So there is a manual, the Commercial Litigation Manual, that the Department of Justice uses as a mechanism to communicate its policy preferences to U.S. attorneys and assistant U.S. attorneys who conduct investigations. So there is a section that deals with False Claims Act cases, and they added some language into that, basically instructing U.S. attorneys that in the event that an organization makes a voluntary disclosure of a problem, or in the course of an investigation, it cooperates, or it makes certain remedial actions, the government should give the organization a break on the False Claims Act penalties. And it lists sort of 10 different activities that constitute forms of cooperation. There are things like identifying the people who were involved in the improper conduct, preserving and collecting the relevant documents, making people available for meetings and interviews and examinations, disclosing facts that you've learned to the government, and that sort of thing. So there are 10 things, concrete actions you can take. And then it also discusses remedial measures. So for example, if you conduct a root cause analysis to figure out why a problem happened and take steps to correct it, that is that's helpful and gets you credit under this policy.
Yeah, I'm going to jump in really quick.
Please.
There's a link to this document on the invite to the webinar, correct?
That is an excellent point. Thank you, Kevin. And so actually, it's not the invite to the webinar. It's we sent out an alert on Monday that has it. So a little blurb.
So anybody who has RSVP'd should have access to can just click on that link and pull up the policy right away. I think it links to the DOJ commercial litigation policy, but if you scroll down to section.
Actually, I think the hot link should take you right to the thing.
Oh, okay, very good. All right.
And so that's what the policy is. So now I guess my first question for you, Kevin, is this a good thing or is this a bad thing?
I think it's a good thing. I think it's a positive development to have all this in writing because it's going to give lawyers who are advocating to the Department of Justice on behalf of their clients new and more robust arguments to make that based on their cooperation, the government should give them a break on the multiplier that might be applied to any settlement amount, as well as the application of penalties.
Well, so how does the multiplier work?
So typically when you settle a case with the Department of Justice, if you have damages you need to pay back based on false claims, the department will be asking for you to not only pay back the monies that it believes were wrongly taken by the organization, but also to pay a multiplier on top of that. And typically those multipliers were somewhere in the 2 to 2.5 range. This document lays out that if you cooperate with the government and provide assistance and investigation, promptly disclose and do all the things we're talking about, many of the things that you do normally in the context of settlement negotiations with the government, you can get a break on your multiplier all the way down to a 1.0 multiplier. Basically, you're paying back the money to the government that they think shouldn't have been paid out in the first place, and that's where the damages end. And that would be a pretty significant benefit to a company that was negotiating a settlement.
And I wrote this little blurb on Monday, and I wasn't crystal clear because they also do include in that 1.0 the lost interest, the cost of the investigation, and any money that's going to a relator in a False Claims Act case. And so I wasn't clear about that. It wasn't just your actual damages, it's sort of your actual damages plus that amount. But that's wildly different from what we've heard before. I know I was just at a situation where an organization had voluntarily disclosed something I would normally have just taken to the contractor because I think that's usually the best way to go. But for unique reasons, they wanted to do it through the False Claims Act disclosure process. And we were told the lowest the government will go is 1.5. So your damages and an extra 50%. And under this guidance, would they have more flexibility?
Yeah, absolutely. I mean, I don't know if they'd have more flexibility. I think they've always had flexibility, but I think it's easier to argue that they have flexibility now, and there's more pressure on them to demonstrate flexibility because of this policy. And this is on top of other related guidance that's come out of the Department of Justice, suggesting that U.S. attorneys' offices need to take a more active role in policing False Claims Act cases, looking closely at the merit of those cases, and working with companies as opposed to taking a hostile, adverse approach to every lawsuit that comes across their desk.
I think Kevin's hinting at one really important point here. This is not a requirement, right? This is not a promise. You can't sue based on this document. It's policy. And so I think Kevin's point is the government always could have gone down to 1.0, but as a matter of policy, they were sort of holding the line at 1.5. And this suggests that that policy has loosened a bit. Now, it's interesting. There are different approaches, but in litigation, you're often dealing with two things. There's process and there's substance. And some litigators are fans of saying, we are going to focus on the process. We will make discovery difficult. And that has not historically been my approach. And I'm a fan of let the facts speak for themselves. We're not going to fight over discovery. We're going to fight over the substance. And I'm curious, Kevin, as to your thoughts on that and what this guidance, what the implications are for that strategy with this guidance.
Sure. And the guidance itself makes the point that simply complying with subpoenas and discovery requests isn't considered cooperation by the Department of Justice. But there are ways to engage in that back and forth that occur whenever you get a CID or the government contacts your client that can make the process easier for the government to understand what in the production of documents is relevant, what employees might have information. Making people available is one of the things that's listed in this guidance as a factor for encouraging reduction of penalties and multipliers. So it's not just providing the government with information, but helping the government understand what happened, I think, is something that occurs pretty commonly in my experience in these kinds of cases. And that doesn't mean you have to take a position that you were wrong in what you did or that you submitted false claims, but the posture that at least in the beginning of the process, you're working with the government to determine what happened. I think that's what the government is looking for, more folks to do that kind of.
And I'm a big fan of the strategy of friendly but firm, which is there's no reason to be antagonistic or jerky. That also doesn't mean you roll over. And with one big exception, if you think you were wrong, I actually am kind of a fan of rolling over then. But if you think what you did was all right, I think it's good to hold the line, but you hold it in a really respectful way. And if the government disagrees with you here, this, I think, creates the flexibility that whatever the amount you pay shrinks. So, Kevin, do you think, is there an organization, you're out there listening to this right now, you're not in the middle of a False Claims Act case, do you do anything differently because of this guidance today?
I don't think this will change my approach to how I analyze responding to CIDs and working with the government. I think the way this will change my practice is that it gives additional ammunition when talking to the government.
But I'm saying not so much for your practice, but for the clients who are listening to us right now. Should they, do you need to go out and do something differently today because of this guidance?
No. I think this is just another tool in the toolbox whenever you're confronted with a CID, and it should spur conversations with your lawyer if your lawyer is advocating a specific approach with the federal government in response to a CID. This is definitely something that should be discussed, the potential to benefit from this new policy.
Now, there is one other kind of cool thing, and this isn't exactly new, but there's a hint that if you've got an effective compliance plan, that can be a factor also in lowering your penalties. And that's, I guess that is a little new. Generally, what I've heard from the OIG, for example, is that you better have a compliance plan, and the failure to have a compliance plan would be a factor in the government deciding they're going to impose a CIA on you. But there hasn't been much of a sense that in the False Claims Act world, you get a discount. Now, that's what I've heard in speeches. I will tell you from personal experience that when attorneys believe that your organization is really trying to do the right thing, I've seen vastly more flexibility. I am a big believer that almost everyone I've ever dealt with in the government is fair and rational. And there are exceptions, but by and large, they're pretty fair and rational. And if they sense that you're trying to do the right thing, they generally don't throw the book at you. The exceptions are memorable, but they seem to be pretty rare.
Right. And I think the my big takeaway from this memo is not just that there's new ammunition and new opportunities to benefit a client in the situation where you're cooperating and providing information to the Department of Justice. It's that the trend from the day when the Yates memo issued 4 years ago has been towards increased collegiality and working with companies that are under investigation as opposed to taking a hard line.
And Kevin, I'm going to interrupt for a second. We should start in a second, but if you want to just describe the Yates memo real quick.
Sure. So the Yates memo was a memo that came out and explained that companies need to be providing information to the government, the names of individuals who might be personally liable for False Claims Act violations, and essentially taking a harder line on individual liability under the False Claims Act. Part of the Yates memo provided that, sorry, my phone is ringing here. Let me hide that away. Part of the Yates memo suggested that cooperation be available in kind of a generalized sense. This is guidance that's way more specific, but it did also indicate that a company seeking to cooperate needed to provide all relevant facts and essentially set up an all or nothing type cooperation arrangement. That has become relaxed over time, and I think that demonstrates that the DOJ is not taking a softer line, but taking a more pragmatic approach to how it handles these cases, and one that more accurately corresponds with the reality of companies' liability and behavior.
So I think the bottom line is good news for everyone except possibly the individuals who now, if they get thrown under the bus by organizations. All right. I want to talk about Kevin briefly and say he reads False Claims Acts for a hobby, and he knows a boatload about this medical marijuana stuff, and that's all we need to do for introductions, because introductions aren't important. Kevin, if you could explain what people need to know about medical marijuana and the healthcare provider.
All right. Thank you, David. Okay, so there's a lot of people have registered for the program. I think we have pretty good attendance. I'm going to leave time at the end of my presentation, 10 to 15 minutes, depending on how things go, to take questions. But this topic especially, I think, really benefits from discussion during the presentation. So please, as you're listening, if a question occurs to you, just submit it. If it's something I'm going to talk about later on in the presentation, I may hold on it for a few minutes. Otherwise, I'll address it at the time. But I like these presentations to be conversations to the extent possible, because I think it's more fun that way, more entertaining, and folks walk away with having learned more. So without further ado, medical marijuana and healthcare providers. I'm going to start the presentation with a discussion of where things stand generally with regard to the law around medical marijuana and the conflict between state and federal law. As you'll probably figure out through the course of this presentation, really the analysis of all the legal issues that arise around medical marijuana, it all comes back to how much risk the client is willing to take on to take a specific step, because of the conflict between state and federal law and the essential foundation point from which all the analysis stems, which is that medical and recreational marijuana, all marijuana, is a Schedule I drug under federal law. It's federally legal. According to federal government, there's no currently accepted medical use. It can't be prescribed. It has a high potential for abuse, and it's essentially similar to drugs like LSD and heroin in terms of its value and potential damage to the community. So we'll talk generally as we progress here about the state of the law federally and at the state level, and then we'll talk more specifically about provider issues. But the understanding where things sit in terms of the conflict between state and federal law is important for the kinds of analyses that providers and physicians and medical device companies, healthcare companies, everybody who intersects with this industry that's where everyone needs to begin, because it really informs what level of risk you're undertaking as you think through the issues that crop up. So current federal law, again, it's illegal. It's Scheduled I drug. The manufacture, sale, and distribution of medical marijuana violates the Controlled Substances Act. CBD, which is cannabidiol, it's another chemical that can be derived from the cannabis plant, is now federally legal. The Farm Bill last year, which we'll talk about in a few minutes, legalized hemp, and you can derive CBD from hemp as long as it's got less than 0.3% psychoactive ingredients. That's typically THC. It can be added to hamburgers, as we just recently learned when Carl's Jr. had its CBD hamburger promotion. So everywhere you look now these days, there's CBD lattes, CBD dietary supplements, and we'll talk about all that more in a few minutes. But marijuana itself and cannabis remains illegal. CBD is federally legal, and actually the DEA has rescheduled cannabidiol as a Schedule 5 substance. State law. California was the first state to legalize medical marijuana. This is back in 1996. Since then, we've got 33 states that have legalized it either recreationally or medically. And that includes full legalization in 10 states. Basically, the entire west coast of the United States, from Alaska through California to Hawaii, is legal recreationally. Then you've got increased legalization in the West, Oregon, Colorado, Nevada, and now you've started to see it out on the East Coast, Maine, Massachusetts, Vermont. The trend is for increased legalization. There has not been a state so far that has rolled back its legalization regime. Some places have progressed in fits and starts, but as of today, there's no place that legalized medically and then rescinded that legislation or that ballot initiative. You'll see on this slide, I note that Vermont is the first state to legalize legislatively, and that's an important marker. The way that medical marijuana legalization occurred and the expansion of medical marijuana occurred, it began with ballot measures in places like California, Washington, Michigan. In those states, because it was legalized through ballot measures, there tended to not be a very robust regulatory framework in place when legalization occurred, and the legislatures came in after the fact and tried to put together a regulatory framework. After a critical mass of states had legalized through ballot measures, states began to legalize medical marijuana legislatively. During legislative legalization of medical marijuana, legislatures were able to spend time creating regulatory schemes that kept the industry under pretty good control and provided some assurance to the federal government that things were not going to be crazy in these states, that there was going to be some, I think it increased the trust for the federal government. And the trend changed from ballot measures to legislative legalization, and that ended up, I think, reinforcing the relaxation of federal prohibition, which we'll talk about in a second. Now that we've entered the legislative legalization phase of recreational marijuana, I think we're going to see the same kind of trend occur, that as states begin to legalize legislatively, it's going to cause even greater relaxation of the federal prohibition, because the recreational legalization is going to result in more robust regulatory schemes on that front. So California legalized medical marijuana in 1996, and states followed, and the availability began to expand over the next 15 years, 20 years, to the point where people were beginning to enter into businesses, and the cultivation and distribution of medical marijuana was becoming so widespread that the Department of Justice felt that it had to take a position on what kind of activity under state medical marijuana laws was going to catch its attention. And this led to the issuing of what's called the Ogden Memo in October of 2009. David Ogden was a deputy attorney general, and this memo provided guidance to federal prosecutors out in the states, the U.S. attorney's offices around the country that were in states where marijuana had been legalized medically. And it essentially made the point that prosecutors should not focus on folks who may be violating the Controlled Substances Act, but were doing it in the context of their own business or just patient activity. that was in compliance with the state's medical marijuana laws, and specifically pointed out prosecuting caregivers or individuals who were administering medical marijuana was not a good use of resources. And it listed off some commercial enterprise characteristics that it suggested should get the attention of the local prosecutors, including the kinds of things that you would think would get the attention of local federal prosecutors: selling marijuana to minors, evidence of other illegal activity connected to the medical marijuana business. Those kinds of things should trigger interest by the prosecutor and may provide a rationale for prosecuting, despite the fact that the guidance from the department was, going forward, if people are in compliance with state law, let's not go after them. So when the Ogden memo came out, there was wide celebration in the medical marijuana community because they read this as basically legalizing federally what they were doing. It's okay to open a business now. It's okay to sell medical marijuana now. It's okay to grow plants on your property now. Basically, the days of marijuana prohibition were at an end in the eyes of many in the industry. And that led to even further expansion, further legalization. States continued to legalize and businesses continued to grow. To the point where in Washington state, they had passed a law, the legislature passed a law that provided for state level regulation of grow operations. So state employees were now going to go out and inspect farms that were growing marijuana to make sure it's being done in a safe and appropriate way. When that law passed, the U.S. Attorney in the Eastern District of Washington took offense to it and sent a letter to the governor indicating to her that that he was going to prosecute state employees for aiding and abetting violations of the Controlled Substances Act if they went out and inspected facilities. Shortly after this letter went out and there was blowback in Washington state, a new memo came out of the Department of Justice that kind of retrenched the department's position with regard to medical marijuana. And it made a couple important points that deflated the balloon of optimism that came out of the Ogden memo, and that was the persons who are in the business of cultivating, selling, or distributing marijuana are in violation of the Controlled Substances Act, regardless of state law. Essentially, just because we issued the Ogden memo doesn't mean you can start your business now having a farm growing medical marijuana. And perhaps even more importantly, it had a shot over the bow of banks and financial services providers and indicated that those who engage in transactions involving the proceeds of large-scale cultivation and distribution are violating federal money laundering statutes. In other words, if you're a bank taking the proceeds of commercial activity in this industry, you're committing money laundering, and we care about that. After the Cole memo came out, there was substantial blowback to the Department of Justice because a significant industry had built up in the years after the issuance of the Ogden memo to serve medical marijuana patients around the country. And there was so much money in play at this time that the Cole memo's position, and this is another memo from the Department of Justice from a Deputy Attorney General, James Cole, that the Cole memo was kind of an unrealistic position for the department to take. And it got a lot of political heat and pressure around this restatement of its priorities. Basically, people said, we've been in business, we've been doing this for years, and now you're going to come in and tell us we're violating the law. That's not okay. And the industry had built enough political power that it was able to push back. And another Cole memo was issued 2 years later and said, oh, yeah, wait a minute a second. When we said we were actually going to prosecute you if you ran a commercial grow operation, never mind. We've decided that we're not interested in going down that road. We've decided that we're not going to consider the size or commercial nature of a marijuana operation when we're deciding who to prosecute. So simply because you've started a big business, started a grow farm, that doesn't mean that we're going to come after you. So we're seeing a pattern develop here, which is there's a step towards legalization and liberalization and increased access. Conservative forces in government try to roll that back by making pronouncements about how they're going to increase enforcement of law, otherwise lawfully operating state lawful businesses. That creates its own political blowback. And then the government responds with further liberalization and legalization, which is what happened with Cole 2. Cole 2 also listed out some federal prosecution priorities that were similar to those in the Ogden memo. And importantly, at the same time that the Cole memo came out, Treasury developed some guidance, which it issued in February 2014, that essentially enabled banks to take these funds that were coming from commercial grow operations and other marijuana industry activity without concern for regulatory enforcement. Since the Treasury guidance came out in February 2014, there has been an increase in the availability of financial services. There are still significant concern in that industry about what kind of regulatory risks they take by accepting money from medical marijuana or recreational marijuana businesses. But the important point, I think, is that Treasury was trying to create a market for financial services, trying to calm fears that there was going to be regulatory action against banks that worked with this industry, and trying to increase the availability of businesses to access financial services, which is directly contrary to what was laid out in the first Cole memo, and which is an odd position to take for a federal agency when the activity that it's seeking to promote is a violation of federal criminal laws. A speech from the director of the Treasury Department's Financial Crimes Enforcement Network, which handles suspicious activity reports and regulations around money laundering and those kinds of activities, gave a speech shortly after the Treasury guidance came out, where she confirmed that the intended effect of the guidance was to facilitate access to financial services. So we started out with the Ogden memo saying, all right, we've looked at this. As long as you're legal with state law, we're not going to interfere with you. Conservative forces forced a rollback with the first Cole memo. Then there was political blowback, which led to the second Cole memo, and the Treasury guidance, which encouraged the expansion of these businesses. And that's how things stood for about 4 years until we got the Sessions memo in January 2018. And this memo rolled back all the previous guidance that had been provided about marijuana, the Ogden memo and both Cole memos, and said pretty baldly that marijuana is a dangerous drug, marijuana activity is a serious crime. Essentially, the things that people are doing all over the country, thanks to state legalization, is a serious crime in the eyes of the Department of Justice. And we're rescinding all the guidance effective immediately. And prosecutors are going back to where they stood before the Ogden memo came out. If they are concerned about marijuana activity or the fact that there's a medical marijuana grow facility that's got 5,000 plants in their jurisdiction, they're well within their rights under the DOJ's policies to prosecute those folks. Continuing with the trend we've seen, this attempted rollback of DOJ policy and suggesting that a more robust enforcement climate was going to emerge from the new administration met with its own political blowback. And now we have multiple laws that have been proposed and either made it through committee or at least have co-sponsors in Congress on the House and the Senate side, all of which are meant to address the tension that comes from this state and federal conflict. So you've got clinical trial and research legislation related to the VA and veterans' access to medical marijuana. You've got expanded research legislation in general because there's one facility in Mississippi that is permitted to grow marijuana for research purposes. And that's been the setup for decades. There's only been one place that you could grow it, and research was highly restricted, which prevented some of the prevented physicians and pharma companies and other interested folks from exploring the potential therapeutic or health benefits of medical cannabis, medical marijuana. That's changing. There's been legislation to reschedule marijuana, so it's no longer a Schedule I drug. There's a rescheduling legislation that proposes adding a M to the Bureau of Alcohol, Tobacco, and Firearms, so it becomes the Bureau of Alcohol, Tobacco, Marijuana, and Firearms. There's a State Safe Harbor Act. There's a legislation to restore the Cole 2 memo, and there's a bill, the one that's actually most likely to get passed and enacted in the next several months is the SAFE Banking Bill, which has been introduced in the House and made it through the House Financial Services Committee. It's been introduced in the Senate, but the chair of the Senate Financial Services Committee is a senator from Idaho, which has not legalized medical or recreational marijuana, and so there's less political pressure there, I think, to advance this kind of measure. But essentially, the SAFE Banking Bill provides that banks can take money, loan money, without worrying about regulatory action. That one seems like it has some potential. There's just recently about 40 state attorney generals and the American Banking Association submitted letters to Congress saying, please pass this bill to help relieve some of the issues with the lack of financial services. In addition to that, there is the Rohrabacher-Blumenauer Amendment, which passed in 2014 to the Omnibus Budget Bill and prohibits expenditure of DOJ funds on enforcement against otherwise state legal marijuana operations. And there was a case out of California, the Marin Alliance case. A woman had been the subject of a civil injunction back in 1998, precluding her from opening a marijuana dispensary ever again because the DOJ took a dim view of the way she had run her marijuana dispensary back then. So this injunction had been in place for decades. And she sought to have the injunction dissolved after the Rohrabacher Amendment passed. At the time, it was the Hinkie-Rohrabacher Amendment. It's changed names a few times, but it's now the Rohrabacher-Blumenauer Amendment. Anyway, she sought to dissolve the injunction, and rather than dissolving the injunction, the judge said, well, this isn't giving me grounds to make this go away entirely, but as of now, the DOJ is precluded by this budget amendment from enforcing the injunction, which essentially had the same effect as dissolving the injunction, at least on a temporary basis. There's been another case, MedPoint Management. This is a bankruptcy case where the court considered the Rohrabacher-Blumenauer Amendment and in the context of whether or not the debtor's activities were legal and determined that there could be enforcement brought by the DOJ using its asset forfeiture fund. There's monies that are available at DOJ to commence and prosecute forfeiture actions that don't rely on the congressional appropriations. And so the court said, well, the DOJ can still come after you for forfeiture based on those available funds. So that's where things stand federally. State legislation that's coming up, New Hampshire, looks like it's going to fully legalize sometime soon. Other states that have strong potential for legalizing in 2019, it's either states where the legislature has approved and it's just waiting for signature by the governor, or have gotten at least close to that point: New Jersey, Connecticut, Illinois, New York, Delaware, Rhode Island. So it's kind of the East Coast expansion of legal recreational marijuana. I think we're going to see more of that in 2019. And in Minnesota, we have bills related to legalizing recreational marijuana that are kind of percolating in the system. At this point, they're stuck in committee or have been killed in committee. The governor supports signing a bill, and I think that we'll see legalized recreational marijuana here within the next year or two. It just depends on when the Minnesota Senate decides to pass a bill, because I think it can make it through the House right now. In the meantime, in Minnesota, we have increased the scope of our qualifying conditions. Typically, the way that state-level legalization of medical marijuana has been implemented is either a doctor has to certify you as being eligible or diagnose you with a qualifying condition. In Minnesota, we have a qualifying condition regime. So you fill out a application to participate in the program. The doctor has to sign it that indicating you've been diagnosed with one of the qualifying conditions under the statute. Since Minnesota legalized medical marijuana a couple of years ago, the number of qualifying conditions have increased, and now it includes autism, PTSD, intractable pain, Alzheimer's, sleep apnea, and that trend is likely to continue as well. In 2018, the Farm Bill was passed, which legalized hemp, as I was talking about earlier in the presentation, And that led to the widespread availability of CBD, cannabidiol, which is a cannabis-derived compound but doesn't contain any psychoactive ingredients. Notably, the Farm Bill preserved the FDA's authority to regulate products that contain cannabis or cannabis-derived compounds. And in a second, I'm going to talk about how the regulatory scheme appears to be enveloping this new industry. The trend has been an exponential increase in the business of medical marijuana and now recreational marijuana, about $10 billion last year in revenue from legal cannabis operations, about 211,000 people directly employed by the cannabis industry in the United States. Major corporations are purchasing grow operations. Since Canada has legalized recreationally, the giant market has emerged there, and these companies are essentially positioning themselves through their Canadian operations to have nationwide U.S. operations whenever it becomes fully legal here, which I expect will probably happen in the next 5 years, would be my guess. Pharma companies are getting involved. GW Pharmaceuticals is one of the first approved cannabis-related drugs. There are ancillary businesses, accounting businesses, greenhouse businesses, ag supply businesses, chemistry and lab equipment that's unique to the industry, security for the grow operations, a whole secondary industry servicing cannabis has emerged. And there have been there's been an increase in the number of publicly traded cannabis-related businesses, and there are now dozens of marijuana stocks available with market cap of $200 million plus, and several with market cap of $1 billion plus. So when you see all these trend lines, and you see how the cannabis industry has expanded, and the political blowback to attempting to enforce or restrict the availability of medical and recreational cannabis has played itself out, it's pretty clear where things are headed. But all this is important to keep in mind when you're assessing your risk tolerance. Every entity that deals with the issues that come out of the federal prohibition on distribution, use, and manufacture of cannabis, every company that has to deal with those issues is going to have a different risk tolerance. But these broader trends and issues are important to keep in mind as you proceed. So let's see here. I'm going to skip ahead. I had a couple slides here on the litigation and regulatory issues that have emerged that are just further evidence that this is becoming ensconced as part of our economy, and not our black market economy, but our everyday economy. So let's talk about healthcare. The FDA is positioning itself to be the agency that regulates cannabis. It has issued warning letters and attempted to impose itself in the regulation of CBD-based food and cosmetic products, as well as pharmaceuticals. It approved the first CBD-based anti-epileptic drug in 2018. It's referred manufacturers to its botanical drug development guidance and implied that that relates to cannabis-related medicines, even though growing cannabis is illegal under federal law. It has approved 3 cannabis-related drugs, Epidiolex, Marinol, and Syndros. Epidiolex is a CBD-based drug. Marinol and Syndros are synthetic THC-based drugs. So there's no approved cannabis-related drug that's actually derived from actual THC or from the other cannabinoid compounds that are in cannabis. But the research on those compounds is ongoing, and I think it's only a matter of time before we start to see pretty robust cannabis-related pharmaceutical industry. The FDA has stated that it treats products containing cannabis or cannabis-derived compounds as it does any other FDA-related products. Essentially, again, it's laying its stakes here that staking out its territory, I should say, from a regulatory perspective, that it's going to be the agency that controls industry once it emerges. And it's actually holding a hearing on May 31st regarding what its role should be in cannabis regulation and CBD regulation. I checked the other day, there are about 530 comments, and it's going to be interesting to follow what happens in the wake of that hearing. But I think the way this is playing out, this is going to be similar to the alcohol and tobacco industries. So there's going to be some state level regulation, there's going to be FDA regulation, and that's going to be the agency that takes the primary role in determining what's appropriate and what's not. CMS, oddly, has been basically silent on this issue. If you go to cms.gov and search for medical marijuana or medical cannabis, you get 4 results. They're all kind of oblique references to medical marijuana, although they do imply, these oblique references, they do imply that medical marijuana is something that might be included in a survey answer about a patient's non-dietary supplements, non-pharmaceutical. You're listing what a patient is taking for the purposes of monitoring treatment, that you might include medical marijuana on those survey responses. Other than that, it's said almost nothing. Medicare condition of participation is compliance with all applicable federal laws, and that includes obviously not having controlled substances, Schedule I controlled substances being distributed on your property. That said, I have not seen any enforcement action against a hospital based on its the use or administration of medical marijuana on site. The one statement that I've been able to track down is from an email back in 2009, so 10 years ago, where California Association of Health Facilities sent a letter to CMS saying, hey, people are asking if they can consume medical marijuana on site at our skilled nursing facilities, and CMS essentially said no. Federal law prohibits a skilled nursing facility from dispensing medical marijuana. Now, this was in an email response to a letter. It's obviously not an official pronouncement. And again, obviously, people are consuming medical marijuana at healthcare facilities all over the country every day. That's something that's occurring regularly, and I haven't seen any enforcement action yet. There are some specific issues that are implicated by physician involvement with medical marijuana and medical cannabis. The most obvious and fundamental is that you put your DEA prescribing license at risk by administering a Schedule I substance. The DEA specifically prohibits you from doing that. Obviously, marijuana can't be prescribed as a Schedule I substance, and the state legal regimes for medical marijuana sale and distribution all involve certifying or qualifying patients, not actually prescribing it. It's not treated like a medicine. So prescribing has not really been an issue, but administering is something that could theoretically put a physician's license at risk. And again, I'm not familiar with any enforcement action against administration, but theoretically it's possible. There was a case out of the Ninth Circuit, it came out of California. The Ninth Circuit case is 2002, related to license revocation for discussing medical marijuana. This is an administration, but it was a doctor who was helping their patients obtain marijuana. And the court held that there's a First Amendment right for doctors to discuss medical marijuana with their patients. However, it noted that aiding and abetting and conspiring with a patient to get marijuana could theoretically violate the Controlled Substances Act. More recently, Nevada Attorney General's office has opined on what involvement doctors can have with the medical marijuana industry, and has indicated that you could put your license at risk, at least in Nevada, by becoming a shareholder, owner, investor, officer, employer, managing member of a dispensary or a medical marijuana establishment. I'm not sure what establishment means, but I would expect that extends to grow operations, manufacturers, companies that are creating edibles or distilling product down. So that's another thing to be aware of if you're a physician, is that getting financially involved within the industry could implicate your license. And then in one of the kind of more interesting developments, the Massachusetts board engaged in an action versus a physician there, and his license eventually got pulled, but primarily because he had been discussing and certifying patients as eligible for medical marijuana without really knowing anything about their history. He was one of the highest certain numbers of certifications in the state for a physician, and he wasn't looking at medical records, consulting with other caregivers, and was essentially just certifying, apparently based on the business imperative of certifying as many people as possible. But in the course of issuing its opinion, the board also looked at whether or not he had violated his standard of care with regard to a specific patient who was pregnant. He had provided certification to this patient. And the board opinion, which is really interesting, and I encourage you to look it up if you're at all interested in this, walked through a whole series of considerations regarding what the standard of care would be for a certifying physician. I haven't seen this question really addressed anywhere else. And it included things like, if you don't certify the patient and they procure the marijuana illegally, is there something about the quality of legal versus illegal marijuana that would increase your responsibilities? And does the standard of care require that you prescribe if it sounds like the patient's going to obtain the marijuana illegally? Or if the patient's already smoking, what are the risks of buying illegal marijuana? Should that factor into your standard of care as a certifying physician? If the patient tells you they're going to go out and get it anyways, and that may put them at some physical risk, is that something that should be considered? Should the physician be recommending edibles as opposed to smoked marijuana as part of the standard of care? Very interesting. Oh, I see we have a question coming in across the wire. Somebody has asked, I think with regard to the last slide, where we talked about licensee of the board violates the CSA by becoming a shareholder, owner, investor, officer, et cetera, of a marijuana dispensary. It's Nevada AG opinion. It asked, does that include stock ownership as part of a physician's portfolio? It's a very good question. And it would seem that the AG opinion here is suggesting more direct involvement than simply having it as part of your portfolio. Or if you have, I have Vanguard, Fidelity Vanguard fund. Does my fund include marijuana stocks? I don't know, maybe it might. Is that enough to implicate you? I don't know. It's a good question. Most of the questions that come out of this bizarre dichotomy between state and federal law really have no good answer other than what's your risk tolerance like, and what's the chances that something's actually going to happen to you? What kind of enforcement activity have you seen in this area? The AG issued this opinion in response to a physician question. It wasn't in response to enforcement action, but I haven't seen any kind of enforcement in this area. I guess the question is, what's your level of risk tolerance, and how profitable is the stock? Because that might adjust your decision making as well. All right, so standard of care for physicians in certifying medical marijuana. Professional associations have taken pretty liberal positions. The AMA supports free and unfettered exchange of information on treatment alternatives, generally supportive of at least discussing the potential use of medical marijuana. And I'll say in the last 5 years, as I've been talking about this issue, I think I have seen a growing acceptance of the potential health benefits of medical marijuana in the medical community. I think people are still waiting to see, is it actually helping people, or is it just kind of another herbal supplement with no real clearly defined benefits? But research is starting to come out and suggest that it does have some positive impact. So I think we're going to see more wide support from the physicians associations. The Pharmacists Association supports pharmacist involvement where permitted by state law. And the occupational health nurses and occupational medicine practitioners recommended policies to guide decisions on marijuana use be distributed to all workers, again, suggesting support for the potential that medical marijuana may play in the patient's life. So nobody's come out and said, this is a travesty, don't use it, don't do it. The trend has been towards professional acceptance and growing professional acceptance. And I have another question coming across going across the table. Let's see here. Somebody, I think, commented on my comment indicating or asking, wouldn't it be considered an investor if you had stock in your portfolio? I think technically it could be, depending on how narrowly the AG's office was going to define it. The question would be, what's the risk of enforcement against your license if you have a stock portfolio that includes 500 stocks and you happen to have 100 shares of Kronos, which is a grow operation? Is that going to lead to you getting disciplined by your board of medical practice? And is that a different kind of risk analysis than if you're the third person in a 3-person LLC? You're just a passive investor in the organization, the company, but there's only 5 or 6 investors. I think those, from a risk tolerance perspective, would suggest different analyses. Here's another question. We are in a TRIG, I think this is tri-state area, with all 3 states having different laws for CBD, et cetera. Do our patients need to change how they discuss these marijuana options with their physicians need to change how they discuss these marijuana options with their patients, or how they note the conversation in their notes? Well, I think, Conant v. Walters and just sort of the general enforcement history around this issue would suggest that simply talking about marijuana with your patients is not going to get you into trouble. Even if you're in a state where medical marijuana is illegal. If a patient came in and said, hey, I've heard medical marijuana is legal in California, I've heard about it, can it benefit my condition? If you said, oh, I've seen some research on this issue, and the research suggests that it does benefit your condition, that's not going to get you in trouble. At the same time, having lots of conversations with patients about medical marijuana may get the attention of local law enforcement, or may bring unwanted scrutiny on the clinic or the hospital. And again, this is just kind of a risk tolerance question. How upset are patients going to be? How big of a problem is it going to be to not discuss these issues with the patients? And what's your concern that the local board or the local law enforcement agencies are going to look askance if it turns out that you've been talking about this with a significant number of patients? So I guess the answer is possibly yes. It depends on what kind of discussions are taking place. And we have another question. In states with permitting medical marijuana, what should physicians consider for a patient requesting certification when the patient is a student receiving federal student loans? I haven't heard anything about federal student loans being rescinded because of medical marijuana certification. And I think that's a decision that's really up to the individual patient, as long as they're aware the extent to which being registered in a medical marijuana program may impact their ability to continue to receive federal student loans. I don't see that it's the physician's decision to make a decision one way or the other. It might be something to discuss. And again, I'm not familiar with any patients who've had their loans impacted by participating in a program. And to be honest, I'm not sure I know of a federal loan prohibition or a federal loan provision that would be impacted by participation in a program. Maybe there is some certification that you're in compliance with all federal laws in your federal student loan applications. I can't remember. I just signed them and the money showed up when I was in law school. Okay, another question. In states with legal medical marijuana, are hospitals including this on the home medication list? This is the question that comes up all the time. I think that was the implication of the internal working documents you can find on CMS's website about that actually use the words medical marijuana, is that they anticipate at least that these medicines might be listed on patient surveys like this and on home medication lists. At this point, I think the risk level of listing it on a home medication list is fairly low, but again, it's all about your risk tolerance, especially if the hospital is not administering the medication, if the medication is at the patient's home and the only involvement the provider has had is in certifying or qualifying a patient. I think the risk is pretty low. If you list it on the home medication list, it's just indicating that the patient is taking it. And if they're state legal, I think it's highly unlikely that there's going to be any kind of federal enforcement action. As a matter of fact, kind of the low quantity of medical marijuana or medical cannabis that a person possesses individually for their own consumption is unlikely to trigger the application of federal law anyways. Have you seen any actions against licensed physicians who are certified for and use medical marijuana as required under state law? I have not, but that's another consideration that obviously physicians need to, as I'm going to talk about that a little bit later. That's another thing that physicians need to consider is their use and procurement of medical marijuana going to get them crosswise with their licensing board? I haven't seen any advisory opinions about that either. That doesn't mean they're not out there, but it may be something worth inquiring with your board about. Here in Minnesota, we have protections for both patients and caregivers who are involved with either consuming or distributing medical marijuana that I think would extend to physicians, but it's a state-by-state kind of issue. All right, I better get to my next slide before the next question shows up. This is good though. I like all these questions. It's fun. It makes it more fun for me, and I think probably more interesting for you. All right, I didn't get to the next slide yet. We already have the next question. Would be seen more in the social history patient smokes marijuana. Okay, this is a comment to think about. Where would you list the marijuana on the home medication list? All right, so some hospital organizations in states that have legal medical marijuana have issued template policies that may be worth investigating if you're a provider. The Washington Healthcare Association created a short template policy that's supportive of use and provides use in facilities and provides the kind of requirements you would want to impose if you're going to have your patients using in your facility, including making sure they have a documented qualifying condition, making sure that a non-staff provider is getting their marijuana for them and storing it and administering it if they need help with administration, and that potentially you have edibles only policy so that you're not actually smoking marijuana in your hospital, which seems pretty wise. States like Minnesota, the only medications that are lawful to purchase are tinctures, and we don't have smokable marijuana as part of our medical marijuana regime. Other states do have kind of grow your own medical marijuana programs, and I would expect in those states you might want to consider having an edibles only policy in your facility, since you probably have a non-smoking policy with regard to tobacco throughout the entire facility anyways. Minnesota has its own template policies that came out of our hospital association, and these provide more flexibility than the Washington policy presumes that you're accepting of patient use in your facility. The Minnesota Hospital Association template policies, which are available, if you just Google them, you can find them. They offer several different options in terms of what kind of policy you implement, depending on the risk tolerance of your facility. No use, unsupervised use, or supervised use. They're kind of three different variations on a policy. And each of these policies address patient access to medicine, how you document what's being, the qualifications of the patient, as well as what's being consumed, where it's stored, who's administering it. All these implicate different regulatory and legal risks for a facility. So if you're storing medical marijuana for your patients on site, that's obviously more risky than having them bring it from home or having a family member bring it. Having a family member administer it or the patient self-administer is obviously less risky than having someone on staff administer. It really comes down to what's your concern about, what's your risk tolerance based on all the things we've talked about. And unfortunately, not having much guidance from CMS about what they see as acceptable and what troubles them. Okay, we have another question. Any guidance on home care providers who receive Medicaid, Medicare funding assisting clients who have medical marijuana administration or procurement? That's essentially what we're talking about right now, I guess. And there's no guidance from CMS about that other than the email snippet that I just showed you from a decade ago. That said, CMS is clearly aware that providers, home care providers, and inpatient providers are storing medicine for their patients, acquiring medicine, administering medicine. As a matter of fact, Minnesota's law provides that hospitals and facilities can have designated caregivers who can service more than one patient. So our law presumes that that providers are helping patients obtain and administer their medicine. There's really no guidance other than I haven't seen any regulatory action against home care providers. I think the risks increase the greater number of patients you service and the less structure you have in terms of who's getting what when and how the medication is being procured. States that have legislatively legalized medical marijuana with more strict regulatory requirements, if you're in compliance with those, I think you're less likely to run afoul of any of the agencies. If you're in a state where it's essentially a grow your own program, then you're probably more likely to run afoul, or at least your risks are increased. But again, I haven't seen any enforcement actions against home care providers. That doesn't mean they haven't occurred, it just means I haven't seen anything yet. Any positions put forward by DHS with serving with those with disabilities, the Minnesota Board of Nursing. Here's just getting some more questions here, sorry. Since it's state specific, will other state guidelines be acceptable? I'm not sure I understand that question. And what are your thoughts regarding a physician group developing a policy for physicians regarding how or if they talk about qualified patients for medical marijuana? Okay, so the question from Jerry Williamson, Jerry, if you can kind of reframe your question, since it's state specific, just be a little more, more context about what you mean by it is state specific. I might be able to answer that question. With regard to the first question, we just got any positions put forth by Minnesota DHS with serving those with disabilities. Well, the statute provides that healthcare providers can qualify as designated caregivers under the law. So under Minnesota law, if you can't take your own medicine, you can designate a caregiver, and that gets there's a separate application that's submitted to the state, and you get registered as a caregiver with the state, which allows you to transport marijuana. If you get pulled over by the highway patrol and you've got marijuana, medical marijuana in your car, and you're a designated caregiver, you're good to go. You're legal under state law. If you're not a designated caregiver and you're driving around with medical marijuana, you can have possession crime issues under Minnesota state law. But the statute provides that healthcare providers can have designated caregivers that cover more than one patient. So the statute actually contemplates and authorizes that kind of activity. With regard to the third question, what are your thoughts regarding a physician group developing a policy for physicians regarding how and if they talk about or qualify patients for medical marijuana? It really depends on the state that you're in. Some states, like Minnesota, have a carve-out that says, hey, if you don't want to participate in this program, you don't have to participate in this program. Some states don't have that kind of carve-out, which suggests maybe there's more of a expectation that providers and physicians are going to operate and work in the industry and discuss this medicine with their patients. It really depends on what your state statute looks like. I think as a general principle, it's a good idea because I think it's a good idea to look at what your state medical marijuana law says, find out what your physicians are doing, and make sure that whatever is being done is in compliance with state law. Find out what people's attitudes and perspectives are with regard to discussing the issue with their patients. There may not be consensus. There probably won't be consensus from doctor to doctor about exactly how helpful this is and when it's appropriate. But at least if you know what's going on in the clinic, you can make sure at the bottom line that you're remaining compliant with state law. A lot of states have advertising regulations and preclude specific, some states don't. Some states do preclude specific kinds of advertising, and it's good to know if your physicians are violating that or not. Even in their online bios or in descriptions of the kind of services provided at a clinic, you can run afoul of those advertising regulations. So it's important to find out what folks are doing, check your state statute, and make sure you're in compliance with that statute. Okay, so we got a clarification from Mr. Williamson. It says, since the laws are state specific, will other state guidelines be acceptable? I think what this question is getting at is if you're in California and using medical marijuana, but you're a Minnesotan and you're using it pursuant to your Minnesota certification, what's going to control your use? And if you're a provider, what's going to control your working with that patient? So for instance, if you're a Minnesota provider and a California patient comes in, are you governed by Minnesota law or California law? And essentially the short answer is it's the state that you're in that's going to control. So for instance, if you are a California patient, you can't come to Minnesota and get medical marijuana here. And as a matter of fact, federal law precludes you from bringing your marijuana across state lines. So there has been an issue with interstate travel and folks from one jurisdiction traveling to another with their medicine, and issues with folks who are California residents going to Michigan providers, just hypothetically speaking, and asking to get medical marijuana. You're governed by the state that you're in, but specifically with states where you have to be participating in a registered program, you're not going to be able to participate unless you're in compliance with state law. So that was kind of a convoluted answer to that question. But if you have a follow-up based on what I just said, go ahead and submit it, and I'll see if I can help clarify. Another question: are we seeing any changes in malpractice coverage for states that have legalized medical marijuana? I haven't seen any, but that doesn't mean, again, that there aren't any. All these issues, they change every day, and they're unique from jurisdiction to jurisdiction. I will say, generally speaking, the insurance industry has been pretty cautious in terms of insuring medical marijuana businesses and operations. There have been circumstances where insurers have sought to avoid coverage based on the fact that marijuana is still a federally prohibited substance, a Schedule I substance, and been ordered to provide coverage despite the federal prohibition. So this is another area of the law that's confused and kind of is developing over time. With regard to malpractice coverage specifically, I don't know the answer to that question, but it's a good one. And maybe that can be the subject of my follow-on presentation. All right, so we are almost out of time. I just want to talk very briefly about cannabis and employment. This is another issue that comes up a lot with our healthcare clients is, what do I do if somebody comes in and is applying for a job who's participating in a medical marijuana program, or somebody who's working at our hospital and decides that they want to participate in a medical marijuana program because they qualify. The laws around terminating people for admitting that they are participating in a marijuana program, it really kind of varies from state to state, just like every other aspect of this issue. Some states offer explicit protection for medical cannabis, medical marijuana patients. Some do not. Some states have allowed lawful termination for employees who have been taking marijuana. This Coates case is kind of a seminal case out of Colorado, one of the earlier employment cases on this issue. It wasn't a healthcare provider, it was Dish Network, but they permitted the termination of somebody who was taking medical marijuana. This is prior to recreational legalization there. The trend is towards protecting medical cannabis patients. There are some unique factors, obviously, that arise in the healthcare industry, specifically safety. If your cardiac surgeon is a medical marijuana patient, how are you going to know if they're under the influence when they come into work, if their performance is going to be compromised, what kind of malpractice risk, liability risk the hospital undertake by employing somebody like that. Federal grant compliance. There's a Drug-Free Workplace Act, hasn't really been enforced against employers, but it provides that contractors and grantees have to make a good faith effort to maintain a drug-free workplace. Courts have looked at whether or not the Drug-Free Workplace Act alone allows an employer to get out from underneath the requirement to continue employing somebody or accommodate somebody who's a medical marijuana patient. It's been kind of mixed. Some of these cases, like the Smith case, have said, yes, the Drug-Free Workplace Act gives you a rationale, a reason to terminate someone. Others have not. Most recently, there was a case out of the District of Connecticut, Federal District of Connecticut, and the Saginaw case. That case provided that the Drug-Free Workplace Act did not give you cover. That was just a few months ago. So the law continues to evolve in this area, but the general trend is, even in states where there's no explicit protection of the law, to protect people and require accommodation for people who are taking medical cannabis or medical marijuana. So we are now several minutes over our allotted time. I'm happy to take another couple questions as we close out. I'll stick around for a few more minutes. The bottom line is that things are progressing in a way that's headed towards full recreational legalization. Over time, there have been consistent efforts to reschedule that I think are going to succeed. Eventually, there's efforts to discourage prosecution of people operating in compliance with state law. There's increased access, increased states with full legalization, exponential expansion of business. All these pressures are going to force a kind of a regulatory reevaluation of where things stand with regard to medical marijuana. And I think it's going to be something that's going to be positive because it's going to provide more guidance to folks, and also going to remove some of the fear of getting crosswise with the federal prohibition. So thank you for participating in the webinar, and I look forward to speaking to you again soon. If you have any questions or are interested in any of the materials that I talked about in the presentation, feel free to give me a call or shoot me an email.